Good afternoon. I'm Jim Duff, Executive Director of the Supreme Court Historical Society. I'm delighted to welcome you to our virtual program for today's program with Douglas Rooks to discuss his latest book, Calm Command, the U.S. Chief Justice Melville Fuller in His Times, 1888 to 1910. Doug Rooks is a lifelong journalist, has been an editor at three Maine and New Hampshire daily and weekly newspapers. He's an opinion columnist for more than 40 years. His previous books are Statesman, George Mitchell and the Art of the Possible, Rise, Decline, and Renewal, the Democratic Party in Maine, and First Franco, Albert Beliveau in Law and Politics and Love. He's also written extensively about state politics for over 33 years, earning numerous awards. He's a magna cum laude graduate of Colby College, and he lives with his wife in a 210-year-old farmhouse in West Gardner, Maine. Sounds lovely. Doug joined us in person for a program with the Decor Bacon House this spring to celebrate his book's publication, and we're delighted to welcome you to our virtual stage today, Doug. He's going to share some insights on Chief Justice Fuller to begin, and then we will take questions as we do usually from the audience, and you can submit those in the Q&A box at the bottom of your Zoom screen. Doug, welcome, and the floor is yours, and we look forward to your presentation.
Thank you so much, Jim. I'm very pleased to be here today. So I will just start in. When he was appointed Chief Justice by Democratic President Grover Cleveland in 1888, Melville Fuller was little known either to the public or to his fellow justices. With his predecessor, Morrison Waite, dying less than 8 months before a presidential election that Republicans expected to win and did win, Fuller had to employ all of his political skills to attain confirmation from a Senate already in Republican hands. A highly successful lawyer in Chicago who had argued many times before the Illinois and the U.S. Supreme Courts, Fuller's most important qualification was as a friend and loyal ally of the president, for whom he had helped deliver the vital state of Illinois in the 1884 election. And he also joined a solidly Republican court since before Cleveland's victory, Republicans had won 6 consecutive presidential elections. Cleveland had made just one other Supreme Court appointment before Fuller's. Next slide, please. And there is the Chief Justice himself, who was really known in his day as a handsome devil, and you can see it. So Fuller had to establish his credentials not only with his colleagues, but with a broader public. In the late 19th century, Chief Justices were Washington celebrities, fixtures of the social scene, only one step down from the president himself. And in winning over the public and the court itself, if his biographer can be forgiven an opinion here, Fuller performed brilliantly, firmly establishing himself on both fronts by the time the 2 annual sessions were passed. The 1890s, much like today, were a politically turbulent era, with control of Congress switching back and forth, and the presidency decided by a mere handful of votes in a few key states. And the justices themselves were hardly immune. Salmon Chase, Chief Justice before Morrison Waite, openly sought the Republican nomination while on the bench, as did Stephen Field, a Democrat from California, who was briefly the court's 10th justice during the Civil War, and who was among the most formidable of Fuller's many colleagues. The brief excerpts from the book I will now present tell the story of how Fuller won over the court and then the American public, and are taken from chapter 4, which is called Giants on the Court. Once the October term began, Fuller faced the same challenges that any new Chief Justice would have, especially those new to the court, as most of them have been. Though the court's recognized leader, he has no designated authority that sets him apart from the rest of the 9, except that since the mid-19th century, the Chief Justice assigns the writing of opinions to a particular justice, though only when he votes with a conference majority. Otherwise, the senior associate justice among the majority makes the call. Chiefs get their way when they do through a mixture of cajolery, flattery, persuasion, and tactics, to which Fuller added an unexpected but vital element, humor. When he assumed the helm, he placed a high priority on achieving unanimity wherever possible and keeping dissents, and especially dissenting opinions, to a minimum. In his first sessions, he succeeded in that aim, and even later on, when major cases divided the court, dissents were generally polite, not pointed, and almost never singled out a fellow justice for criticism, even by implication. Achieving such relative harmony was perhaps not as difficult as might have been expected. The court's membership was mature when Fuller joined it, and during his first 7 years on the bench, 2 presidents made 8 new appointments, including his own. It became the Fuller Court in fact as well as name relatively quickly. It was also a time of great ideological turmoil as the rise of dominant industrial corporations and trusts, rapid growth of great cities, and a huge increase in immigration from Europe and Asia placed extraordinary new demands on the political system, and so the courts. Reconciliation, as it was known, with the South saw establishment of legalized segregation there, Jim Crow laws, and violence fueled by racial hatred. Though the war was long over, the nation was far from united. On the court, however, there were no such storms. To a surprising degree, the justices held similar approaches to the law and the Constitution. The 4 appointees Cleveland added, and the 4 nominated by Benjamin Harrison, had discernible difference in their judicial beliefs and methods, but ideologically they were aligned and were as were at least the constitutional views of the presidents who appointed them. All the justices who served with Fuller, even John Harlan, were what we would see today as pro-business and skeptical of the claims of the early labor unions. They also held a narrow view by our lights of the primacy of individual rights and upheld a host of laws and regulations that we would see as discriminatory. That does not mean Fuller had an easy time of it, but he correctly evaluated the task at hand. In his later years, he often told listeners there were giants on the court in those days. The giants were several, including the 2 remaining justices appointed by Abraham Lincoln, Stephen Field, the Democrat from California, and Samuel Miller, a Republican originally from Kentucky, a physician and a lawyer who converted to the cause of abolition, freed his slaves, and moved to Iowa, where he prospered. Miller was a court eminence for nearly 28 years and wrote more constitutional opinions than any other justice up to that time. Like Field, he considered himself Chief Justice material and initially resisted Fuller's blandishments. There were others matching Fuller's description. Joseph Bradley, a Republican from New Jersey, appointed by Ulysses S. Grant, wrote several important opinions and was among the court's most conservative members. It was his misfortune to be cast as the deciding vote on the 1877 election commission that conferred the presidency on Republican Rutherford B. Hayes, but it didn't seem to affect the esteem his colleagues had for him. One illustration of Fuller's technique is a frequently told anecdote from just after the turn of the century, when Oliver Wendell Holmes, who had recently joined the court after a brilliant legal career in Massachusetts. Holmes displayed a pithy, direct writing style that was in dramatic contrast to the court's sometimes ponderous, even soporific opinion writing. Harlan, by that time the senior justice by a decade, was outlining a view of a case when the ever-confident Holmes broke in, violating the rule that the justices do not interrupt one another. But that just won't wash, Holmes said, and he repeated it. Harlan was outraged, and as he occasionally did on the bench, made no secret of his displeasure. Justice Fuller, sensing trouble, began by miming washing clothes on a washboard, and he said, "But I just keep scrubbing away, scrubbing away." The moment passed and decorum was restored. Fuller is credited with another harmony-inducing custom that has been continued by each subsequent court. When the justices gathered in the robing room and in their weekly conferences, each of them shook hands with his colleagues. Though a small gesture, it represented a comedy that Fuller so firmly desired, and despite their many differences on cases, there was rarely any evident ill will among these strong personalities in public or in the written record. Winning over the eminences already on the bench took not only tact, but an individual approach, and Fuller set right to work. Two of those justices stand out since they served with him for many years: Stephen Field until 1897, and John Harlan, who was the dissenter in Plessy versus Ferguson, to the end of his tenure. Stephen Field, I guess we can bring up Stephen Field now. Next slide. There he is. Yes, people said that he looked like an Old Testament prophet, and I think you can see in that wonderful robe what they were talking about. So he was definitely one of the ones who, for the term larger than life, surely applies. And before legal requirements became paramount for judicial advancement, there were judges who resembled Field, but no one quite like him had served on the Supreme Court before, and none have since. He came from a large and remarkable family headed by a Congregationalist minister in Haddam, Connecticut, who then moved to Stockbridge, Massachusetts. His oldest brother, David Dudley, became a prominent New York attorney who authored path-breaking codes of civil and criminal procedure and was a kingmaker in the Democratic Party, as well as an early abolitionist. He was doubtless influential in Lincoln's appointments of Stephen to the Supreme Court, and he also worked hard when Field decided to run for president in 1880. Cyrus, the second brother, went into business and became famous for building the first transatlantic cable to Great Britain in 1858. Cyrus also supported his brother's presidential ambitions, and with David helped ensure that New York Samuel Tilden, who was the popular vote winner in 1876, the one who did not become president, would not be nominated again. You can find the whole story in the book, but to suffice it to say here that Field thrived in the rough and tumble world of a new frontier state, and he had a titanic dispute with one of his colleagues on the California Supreme Court, which ended with that justice being shot dead on a train by Stephen Field's bodyguard. This ultimately produced a unique case, in re Nagel, where the court found the bodyguard immune from state criminal charges, with Fuller dissenting. When Fuller joined the court, a prominent fellow Chicago lawyer predicted, incorrectly, that Stephen Field, quote, will eat him in one bite. He flattered the irascible Field, gave him important speaking assignments, and then praised his performance. Writing of Field's opinions, I can't exactly define what the particular charm is, but I think it is the ease with which a good deal of weighty thought is conveyed without fatigue to the reader. The Chief Justice's measured appeals to Field's vanity ultimately paid off. By January 1891, he was able to write to his wife Molly that Field had told him, in the conferences, I was almost invariably right. He said I was remarkably quick in seizing the best point. He has never said as much before. And then there was John Harlan. We'll cue Mr. Harlan. There he is. John Harlan, whose reputation today is a good deal higher than it was in his own day. He was an exact contemporary of Fuller, both born in 1833, but he was appointed to the court a decade earlier and outlived Fuller by a year. Harlan's 34-year tenure is the sixth longest among all of those who served. Unlike Field, there was no history of dueling and shootings, but Harlan's experience off the court, as well as his approach to cases and the force of his opinions, made him an opposing figure, though his contemporaries often found him more exasperating than persuasive. A biographer may have caught what made Harlan more appealing to later generations than to his own. And he wrote, an intensely partisan man in an intensely partisan era, Harlan often tended to sound as though the apocalypse were at hand, a characteristic that exaggerates the contrasts that abounded in his life. There are only a few instances where Supreme Court justices are seen radically differently than they were while they were on the bench. Roger Taney, mostly due to the Dred Scott decision, is certainly one of them. Oliver Wendell Holmes is another. The aura that Holmes's young acolytes created, Felix Frankfurter in America and Harold Lasky in Britain, was punctured, if not dismantled, by the much delayed release of his private papers many years after his death. John Harlan is certainly a third, but with an enhanced reputation. In his own day, he was seen as a rock-like temperament, supremely sure his view was the correct one. as the only justice of his time to interpret the rights conveyed on the freedmen by the post-Civil War amendments as we would today, he has attained a place in the pantheon. And he's been called the Great Dissenter, although that title at one time was also bestowed on Holmes. What we see as courage was once seen as cantankerousness. As late as 1947, in one of Felix Frankfurter's Supreme Court opinions, he called Harlan's view that the 14th Amendment applied to the states, along with the Bill of Rights, an eccentric exception. And nor, except on racial issues, was Harlan regularly out of step with his colleagues. It was David Brewer who, with wry wit, supplied the classic impression of John Harlan. He goes to bed every night with one hand on the Constitution and the other on the Bible, and so sleeps the sweet sleep of justice and righteousness. Fuller and Harlan voted together more often than not, including on the insular cases, in which the majority, over the Chief Justice's fervent objections, established the second-class citizenship that still burdens Puerto Rico today. In their last years, when Harlan summered in Quebec on the St. Lawrence River's North Shore, and Fuller in Sorrento, Maine, across Frenchman Bay from Bar Harbor, they regularly exchanged affectionate notes. A year after his swearing in, still virtually unknown to the larger public, Fuller seized upon the 100th anniversary of the establishment of our constitutional government to craft his most substantial and compelling statement on constitutional interpretation. So we'll go to the next slide. Yes, this is one of many caricatures of Fuller that, yes, Chief Justices definitely had a different aura in their day, and people were particularly fascinated by Fuller, who was quite small in stature. He was only about 5'4", but he definitely looked the part, at least what the Chief Justice should look like in that era. The vehicle by which Fuller established himself was the historic occasion of the centennial of George Washington's inauguration as the nation's first president, and effectively the chief designer of how the new executive branch should function in practice. So Fuller's address in commemoration of the inauguration of George Washington, delivered on December 11th to Congress, was a revelation, impressing newspaper editors who'd been skeptical of his qualifications. The New York Times said the speech was at once a surprise and a delight to the vast audience that heard it, just as a Times reviewer of the sole previous Fuller biography published in 1950 called Fuller an exceptional chief and a strangely winning human being, despite the reviewer disapproving of much of his jurisprudence. The Washington Centennial Address is Fuller's most searching and polished public utterance. A scholar by nature, he made full use of his voluminous reading. His examination of Washington's character and his approach to government went far beyond the formalities that might have been expected. It's also Fuller's most compact and explicit statement of his own approach to the law, buttressed by a keen appreciation of how the three branches of government interact. Although it does employ the by then traditional patriotic rhetoric, Fuller took care with literary aspects of his speech too. Near the beginning, he uses an arresting simile for the Washington legend. That story comes to console and strengthen, like the shadow of a great rock in a weary land. Imaginatively, Fuller placed himself back in the situation Washington faced after the Constitution had been ratified by 11 of the 13 new states, and some by narrow margins. He did not mince words. An opposition so intense and bitter as that which had existed to the adoption of the Constitution could not readily die out, and the antagonisms which at its base were as old as human nature. Jealousies existed between the smaller and the larger, between the agricultural and the commercial states, and these were rendered the keener by the rivalries of personal ambitions. It does sound strikingly contemporary. So we'll go to the last slide here. And there's a reference to what that is. It's the official printing of this address. The Chief Justice perceives that the first president's task is much like the one that the Supreme Court performs in each term with each case. He delves into political theories underpinning the Republic, as well as the unique character of a single nation created from what were, in essence, 13 dependent colonies turned suddenly into independent republics. In our current conceptions of federal and state governments, we sometimes see the states as minor subdivisions, but that certainly wasn't Fuller's notion. He posited a Washingtonian calculus. Could the conception of a central government operating directly upon citizens, who at the same time were subject to the jurisdiction of their several states, be carried into practical working operation so as to reconcile imperial sway with local independence? Would a scheme work which was partly national and partly federal, and which aimed at unity as well as union? And he concluded his speech with an optimistic appeal to the better angels of Americans that, if fulfilled, would allow the country to, as he said, become more powerful and more noble than the powerful and noble Roman nation. Still the classically trained Fuller's ideal, which stood for centuries the embodiment of law and order and government, but fell when its citizens lost the sense of duty in indulgence and pleasure. Among his converts was the senior justice, Lincoln appointee Samuel Miller. Even a year into his term, Fuller worried that Miller was resisting him. So he was delighted to learn that after the address, it was Miller who suggested to the court reporter that it be published in the Supreme Court Journal, as it duly was. In his reply, Fuller carefully retained his backstage role among the giants and said, "No rising sun for me, with these old luminaries blazing away with all their ancient fires." So it was in this period, a year before Miller's death in 1890, that Miller called Fuller the best presiding judge he'd served with, and a most lovable, congenial man. And though they served together just 2 years, an arc in the court's history was now complete. Fuller had finished his preparation for the eventful 2 decades that lay ahead. And now we're ready for questions.
Great, thank you very much, Doug. I'm fascinated by the book and the study, and having worked for 3 Chief Justices myself, I have a few questions, and we're getting some from the audience as well. I might lead off with a couple of my own and an observation or two. In our last session, in one of our lunchtime series of lectures, we spoke with Matt Hofstadt, who's the curator of the court, and we encouraged visitors to tour the court and see the artifacts and historical exhibits on display. Those who have visited the court will remember, and those who haven't yet, I encourage you to do so. See the conference rooms where the portraits of all of our Chief Justices are displayed. And I can't tell you how many times I've taken visitors through those rooms that someone doesn't ask me, I didn't realize that Mark Twain was a Chief Justice. And I've had to explain, well, that isn't Mark Twain, that's Melville Fuller. They were born about the same time. I think Twain was born, Samuel Clemens was born in 1835, Fuller was born in 1833. They do bear resemblance. Did in your work or research, did you encounter any episodes where they were from contemporaries in which they were comparisons were made between the two?
Yes, indeed. Yes, indeed. And it's interesting, given their relative prominence in public recollections, that it was actually Fuller who was more famous at the time than Twain, who was still an up-and-coming writer and not the colossus of literature that we think of today. And I'm going to see if I can find this, because it's a great tiny little story that we could use here. There he is. Well, of course, the question is, will I be able to find it? But I'm going to take one guess here that it's on this page, and we will see. But I will paraphrase otherwise. But anyway, I think I better just paraphrase. So anyway, people would come up to Mark Twain and expect him to be Justice Fuller, and he would have to tell them he was not. And then he said, "It's delightful to be full, but it's heaven to be fuller." That was the humorous way of deferring this. I don't know when the switchover occurred. Clearly, probably after. I think they died about the same time too. So at some point, Twain became famous, but I think that must have amused Fuller a great deal because he was very obscure when he came out of the court. It was really a question of who is this guy, and what I said in the lecture portion was to try to convey how he did that. How did he become Chief Justice?
That's funny. Um, a good story. It reminds me of one with Justice David Souter, who was
Mm.
out to dinner one evening, and someone came up to him and said, "Justice Breyer, I think you're I admire you greatly. I really admire your opinions, and just tell me, who do you think, in your opinion, is the brightest justice on the court?" And Justice Souter thought for a minute. Well, I'd have to say it must be David Souter, and so, so I think he enjoyed the
Yes, he did.
confusion between the two. Um, Another question that came to my mind, Doug, and from my background is the administrative aspects of the role of the Chief Justice. And Fuller's sort of initiation, I would say, of some of the more pressing administrative changes at the time he was Chief Justice. And then by the time Taft became Chief Justice, they moved some of what Fuller was doing into practice through more statutory structure of the administration of the courts. Can you talk a little bit about um, the workload of the court under Chief Justice Fuller, and what he did structurally within the administration of the courts that really moved us in the direction that and where we currently are today with our appellate court systems.
I'll address a couple of those points. There's another chapter in the book called Crisis in the Courts. And the crisis, when he became Chief Justice, is the Supreme Court docket was hopelessly backlogged. I mean, it was taking 4 and 5 years for decisions to come down because they were just completely overwhelmed. In those days, the court did not choose the appeals it would hear. They just got them from all the circuit courts, which of course came up from the district courts. And in a rapidly expanding, growing nation, they were just becoming overwhelming. And although Fuller did end up authoring 840 majority opinions, a breathtaking total for today, um, he sized up the situation and realized this was a big problem. So he went back to work on something that had been proposed a whole bunch of times before under previous presidents and chiefs, which would establish a new level of court, which we now know as the courts of appeal, which did not exist then. The circuit courts were directly connected to the Supreme Court. In fact, the justices rode circuit and were supposed to be heading up the court on those occasions, which also is becoming very impractical as the nation became larger and larger geographically. So what he did was he decided to hold a welcoming dinner for Justice David Brewer, who I mentioned earlier, a very clever fellow indeed. And he used that occasion to intensively lobby the Judiciary Committee of the Senate, which was going to make the decision on this bill, which was a appeals court bill. And he really did a superb job. Not only afterwards did they sort of indicate that they were now ready to proceed, they actually invited the court to essentially participate in writing the bill, which was a pretty, big
Mhm.
stretch at the time. So the courts of appeal got established within 3 years. The court's workload had been taken care of, and it was quite an amazing achievement at the time. This is unfortunately not the kind of things we most remember chief justices for, but in its day, it was pretty impressive.
A very important, really, move to move the court into sort of a more modern system of management and ultimately self-management of the courts. Uh, at in his time, did he ride the circuits? Did the justices continue to ride the circuits in those days?
He did, and he came up with some interesting decisions. One which my partner on this book, Bob Fuller, a descendant of Melville, likes a lot, is he probated a will in South Carolina, which had it gone otherwise than the way he decided, something important would not have happened. It was the establishment of Clemson University, the
Hmm.
second largest public university in South Carolina. And because he upheld the will, which established an agricultural college on that site. So anyway, that was one interesting case. And it was his very first summer. He was right in South Carolina, and you can imagine somebody from Maine was really having a hard time in South Carolina. And that's what they did in those days. The other a more notable case, actually, an important case, was decided in Chicago. He originally wanted that circuit. John Harlan already had it, and Fuller ultimately decided that he would keep the Virginia and Maryland circuit, which chiefs traditionally did. But Harlan was away on an arbitration case, so he went to Chicago to hear a very interesting case, which was the Chicago World's Fair, or the Columbian Exposition. It was then known in 1893, a very important World's Fair. It was only open 6 days a week, and most people in Chicago then worked 6 days a week. So, working people couldn't go to the fair. So the fair's organizers decided to open it on Sunday, and this came before Fuller, and he ultimately upheld the Sunday openings on his based on his principle of a very complete separation between church and state.
Hmm.
So that became precedent as well. So he did have that role. They gradually faded out after the appeals courts were established, but they continued in some form up to the time of Taft, who finally got legislation that abolished them.
We're getting a good number of questions from the audience, and something you just mentioned raises one of the questions, and that is, while Fuller is known as a man of Maine, Chicago also lays claim to him. Can you talk a bit about his Chicago connections?
It was quite a life and career he had out there. He was there at the perfect time during his lifetime, during the time he was in Chicago, where he really lived the rest of his life. He was Chicago grew from 100,000 people, or even a little less, when he arrived, to over 1 million. And when you think about the explosive growth of that city, which became, the second largest metropolis in short order after New York, it's really quite amazing. And he took full advantage. He was a very canny businessman. His first office building that he owned was destroyed in the Chicago fire. And I don't know, somehow he managed to rebuild it twice as large and continued on as almost as if nothing had happened. Chicago weathered the Great Fire amazingly well. It was such a boom town that people just kept going. And there are some good books I referred to in that chapter. In terms of his own practice, he was eclectic and he did not get pigeonholed, which was very fortunate for him because a lot of Abraham Lincoln probably made some of his reputation and probably a fair amount of money representing railroads. And Fuller did too, but he also argued cases against the railroads as well. So he kept himself much more politically available than some of the lawyers who kind of specialized and did only one thing. He was very proud of his Chicago connections. He was an accolade of Stephen Douglas, which got him into some interesting situations later, because, of course, Douglas's solution to the problem of slavery was very different than Abraham Lincoln's, as we know from the outcome of Lincoln-Douglas debates. But Fuller, abandoned politics at a relatively early age and concentrated on the law, and clearly that was his calling.
Thank you. Another question, a couple of people have asked this. In 2022, the Chief Justice Fuller statute was removed in Maine. The question is, when should, if ever, justices' statutes be removed from public spaces?
This is a very interesting question. I think you have to look at the particular circumstances of the time. The then acting Chief Justice of the Maine Supreme Judicial Court wrote a very unusual letter to the county commissioners in Kennebec County. That's Augusta is the shire town of Kennebec County, as well as the state capital. And they basically asked that it be removed. It was kind of odd because the Supreme Court itself, which was building a huge judicial center, I'm sorry, the Maine judiciary behind the old courthouse, turned down the statute when it was first proposed. and they ended up putting it on the county side. So they had pretty much washed their hands of it already, but they were now calling for its removal. And after the murder of George Floyd, people remember worldwide what that atmosphere was like. And I think it was just a case of bad timing for Justice Fuller. The
No.
statue was removed and is currently in storage. But the question of statues is a fascinating one because they are symbols, and what are they symbols of? The statue itself was kind of people in Augusta had kind of an affectionate relationship with it. Um, During the winter, he would sport a stocking cap. It's a seated statue. It's not a grand thing at all. And during the early pandemic, he was wearing a mask. Um,
Mm.
I think it came as a bit of a shock to me anyway, because and it did promote my interest in doing this book. Who was Melville Fuller really? And as usual, we find out he was a lot more complicated, but I would say a lot more interesting than I had
Mhm.
thought.
Mhm. He made important state. Here's another question from the audience. He made many important statements on human rights, promoting majority opinions, respecting the rights of Native Americans in the death penalty cases, stopping near automatic imposition of the death penalty on Native Americans charged with homicide, often in cases that appeared to be self-defense, and in dissenting opinions advocating citizenship rights for the people of Puerto Rico. Why doesn't Fuller get more recognition for these cases? And let's talk a little bit about some of those cases and the insular cases. Please.
The insular cases was a completely unknown thing to me, but not just to me. I mean, they had pretty much vanished into history, even at law schools. And Harvard Law School, which had been influential in some of their law professors, wrote articles about the acquisition of Puerto Rico, the Philippines, and Guam. Those were the big three territories that we acquired as a result of the Spanish-American War of 1898. And they held a conference about 10 years ago, mostly because none of them had ever heard of them. So these are important cases, and they really bear some scrutiny today because we have in Puerto Rico, which of course the Philippines got their independence. Guam still exists, but primarily as a gigantic military base. There are very few non-defense related civilians on Guam. There was no native population there. Um, but Puerto Rico clearly is very different, a very large, very populous, very well-established government. I mean, it's a lot older than the United States. So what happened? Well, what happened is this. The war was really an outburst of American imperialism of very unabashed quality, which was different than our previous wars. We basically obliterated the Spanish Navy in Cuba and over in the Philippines, and basically could have what we wanted, which was, in this case, these island or insular, that's why they're called the insular cases, referring to islands. Um, Originally, the Puerto Ricans were celebrating the arrival of American troops, and they sent representatives to Washington with the idea of attaining statehood, which was then a fairly, we just admitted about five more states 10 years earlier. So it didn't seem to them like a huge problem, but it was. And I think we can guess why. This was not only an island with a population that looked very different than most Americans of that day, it was also Spanish speaking. So it fell largely to President William McKinley to kind of sort this out initially. And what he did was very interesting. He decided that the Puerto Ricans were up to speed on the judicial system. So they're fully incorporated into the federal judiciary, including there's a judge now from Puerto Rico on the First Circuit Court of Appeals. However, that judge cannot vote for president. That judge has no representation in Congress. That was what Congress came up with in the Foraker Act, which established the law for Puerto Rico. So at that point, the court had many cases, all bearing on the status of the islands. Ultimately, the court, and this was something that, as I mentioned, Fuller was fervently opposed to, but he could never really muster permanently more than 4 votes, was that there cannot be any difference in status in a territory and a state, because that's what John Marshall had handed down 100 years roughly earlier, and that had been the law up to that point. Essentially, what was accepted was the doctrine that Justice White who was Chief Justice after Fuller, decided was the doctrine of non-incorporation, that there were certain places that were not incorporated into the United States until Congress said so. So that's the basis of it, and it has held up for 120 years since then, that Puerto Rico has a different constitutional status than any other part of America.
Another question from the audience. Chief Justice Fuller served as a member of the Permanent Court of Arbitration in The Hague. Can you talk a bit about that experience?
That was a really interesting one because it was a brand new institution. The European powers, this was, of course, was before the cataclysm of World War I, but there was a lot of interest in what we would now call international law and settling disputes without reference to war. Um, so the so Fuller was, well, he got the, I think he got the job at the Court of Arbitration because he had served as an arbitrator in a boundary dispute between Britain and Venezuela, which he did such a good job that the British ultimately selected him as their arbitrator in a famous case called the Muscat-Dow's case. In case you're wondering what that, Muscat and Oman is in the Persian Gulf, or I'm sorry, the Arabian Gulf, and the Dow is our ships, our trading vessels. And long after the Civil War, the Dows were still carrying slaves. There was a healthy slave trade between Africa and Arabia, and the French were sort of complicit with this, whereas the British, who, as you know, were the first nation to abolish slavery, wanted to end it. So this was the conflict that they were trying to settle. And the court of arbitration did that quite successfully. It was a binding arbitration. Both sides accepted it. And it basically set terms that led to the extinction of the slave trade. What it also did, and this is quite significant, was establish what we now call the flags of convenience, that each sovereign nation can flag whatever vessels it wants. And this has had profound consequences on the maritime trade ever since then. It's the basis of, why so many ships that are American, in essence, are flagged somewhere else. So anyway, that was the only case that he decided. It was the early days for the court, and there weren't many cases, but that one certainly stands out. And I really love the connection with the end of slavery. He doesn't get such good reviews on Plessy versus Ferguson.
What do you consider to be his most important contribution to the Supreme Court's jurisprudence?
Well, this is the interesting thing. As I explained in the book, Plessy was a pretty minor decision in its day. It seems very different now. I think really the most important case, it's certainly in his view, and I think those of his contemporaries, were called the income tax cases, when the Democrats under Grover Cleveland passed the first peacetime federal income tax. Ultimately, Fuller's court struck that down by a 5-4 vote based on the direct taxation clauses of the Constitution, now very obscure, but then very important, because it was the idea that the federal government could not act upon individual citizens directly. And this was what an issue that he referred to in the Washington address. Does the national government have the right to control individual citizens? And this was very much an open question at the time. And his decision and that of the majority of the court was that the income tax, it was a progressive income tax based on income and wealth, was unconstitutional. But that's really not the end of the story, because in the opinion that he wrote, there's a very elaborate presentation of how to amend the Constitution, and for specifically about this issue. He basically said, this is what the Constitution says now, and if you wanted to say something else, you have to amend it. And that's what Congress did. Just before he died, they passed the 16th Amendment, the Progressive Income Tax Amendment, and it basically takes its language right from his opinion. It allows Congress to impose an income tax without apportionment, meaning per person, and essentially legalize what is now the mainstay of the federal government and most state governments as well. So I like the other thing I like about that story is we have a justice who did more than simply strike down a piece of legislation that was objectionable in some way. he really saw himself as performing in the realm of the entire federal government, and he had excellent relations with Congress as well as most presidents. I think that's something we might be missing a little of today.
What was his relationship like with his colleagues on the court? You alluded a little bit to it earlier, but how would you describe the court and its collegiality or lack of, if it at the time?
Well, considering you had somebody like Stephen Field on it, who clearly thought he knew the best about everything, there were all sorts of interesting cross currents. I mentioned David Brewer. This is
Mhm.
the only case that we know of. I think it's the only case where Stephen Field was David Brewer's uncle. And when Brewer got on the court, he kind of expected Brewer to vote along with him, obviously, because they were family. And Brewer did not always do that. So there was a little bit of kerfuffle about there. There was an even more interesting incident when Field was clearly very old and failing, but would not resign from the court. He was very determined to stay on. And Fuller managed that really well. He did not pressure him, but he finally visited Field he sent David Brewer as one of his emissaries, and they got Field to agree to resign. And then they immediately put it in writing and sent it off to the president. Um, it's a delicate thing dealing with the justices. This group was very diverse. Oliver Wendell Holmes, a really big figure, came onto the court in 1902, and Fuller not only welcomed him, they worked very well together. And this is very interesting about Holmes, too. We now see him in many ways as the great dissenter, the great decisions on free speech issues, particularly assembly. But with Fuller, he was not that way. He voted with Chief Justice most of the time, and I do think he was actually influenced by Fuller's jurisprudence before he developed his own in his very long and distinguished career after Fuller died in 1910. So it was a constant challenge to the chief, but I think his early life, which you'll read about in the early chapters, was very helpful to his abilities to arbitrate, to mediate, and basically to keep a lid on when things were getting hot.
Is that the title of your book, Calm Command? Is that where this comes from? Let's talk a little bit about the book and the process and how you came to write it. But let's start with the title.
Well, the title emerged at some point. I can't remember exactly when it hit me, but I realized that particularly books on things like chief justices tend to have somewhat long and ponderous titles, and I didn't want that. I wanted something that might catch the eye of a more casual reader or just somebody who's interested in the court, but not exactly wanting to wade into a very lengthy account that didn't have many anecdotes or good quotes in it. I tried to convey it to include those in the book. But as the book developed, I was very struck by the range of his opinions and his he was a great reader. He had an enormous library that you can see in a picture of his study. He lived in Washington, D.C., in the Dacor Bacon house that you mentioned. I sort of sneakily call it the Fuller House, even though I don't think it was ever known that. But he was the first its associations with chiefs. John Marshall boarded there, and Fuller lived there and owned it. And I like to think of that connection because anybody who's connected with John Marshall's, their standing goes up. It really does, particularly in the court. So I think it was, well, Bob, I mentioned Bob Fuller. Hi, Bob. I hope you're on today. I think you will be. And it was a real partnership. He liked to call it a partnership, and it kind of was because he had the interest in getting a book out about this famous relative who was, very obscure and neglected by the time I began the book. So it was partly a matter of establishing him, like, who is this guy? But then following around in the various fields that a Supreme Court justice inevitably gets into, the arbitration experience, the boundary disputes. Um, he was, in his own way, a very impressive figure, but very modest. He never really stood out. Nobody ever, looked at him and said, "My goodness, what did you say?" He worked very differently than some, the big egos on the court, of which I mentioned a few, and there were more. Um,
Mhm.
it's very difficult to keep nine extremely independent personalities from all parts of the country, appointed by different presidents, really in line. And he did it with tact and I think a lot of his personal skill. Um, that is something that I think is one of the most notable things about his chief justiceship.
And did his colleagues voice that? That is,
He
they
did. I quoted I'm sorry, Justice Miller, and his first biography picked up on this. Oliver Wendell Holmes, who then served for quite a long time after that, also referred to Fuller as the best presiding judge. So you can go all the way back to Lincoln and forward to the end of Holmes, and at least among some certain of his colleagues who were willing to write and speak about it, he was the best presiding justice. They didn't say the best writer, the best decision maker in terms of the court's outcomes, but as a presiding judge, he was apparently unsurpassed.
interesting. Uh, oh, what surprised you? Here's another question from our audience. What surprised you most as you were working on the book?
Well, it was discovering these subjects that I didn't know much about. The insular cases was probably the most prominent example, but the death penalty cases that were referred to in one of the questions earlier, very, very notable because, we're talking about frontier justice here. The judge in question, who was known as the hanging judge, very appropriately, he sentenced an awful lot of people to death. He was sitting in Arkansas, but his jurisdiction originally included the Oklahoma Territory, the brand new Oklahoma Territory, in which there wasn't a whole lot of law initially. And some of the cases, there's one I cite in particular where a young man who was feared for his life from his father, and he basically, got a gun and said, if you come around, I'm going to do this. And sure enough, the father showed up. He was shot dead by the son and then sentenced to death by this quote hanging judge from the Arkansas Territory. Fuller reviewed that case, and basically it's a very artful opinion. He doesn't simply overturn the case because that's an unjust result. He says that the question of the of whether it could be considered self-defense was a question for the jury and not the judge to decide, and that's what happened there. So it was basically sent back for resentencing, and there was a new trial, and the he didn't get off, but he obviously wasn't executed. And there's a certain link here with some of Fuller's other cases. There's a lot of doctrines that we now find offensive, the freedom of contract particularly, which is the idea that if you go to work for somebody, you're free to do that and you're free to leave at any time. And the employer really has no more responsibility for you, even if you're injured on the job. A system that we now know as workers' compensation did not exist. And in those cases, the legal doctrine that the court continued to uphold was, absolute freedom of contract. Fuller kept edging away from that. He clearly had a lively interest in the people who were the subject of the cases before the court. And I would say he was more humane than many of his fellow judges who were more ideological, perhaps, and arbitrary in following the law. He didn't always contest their legal findings, but he tried to soften them.
Interesting. What led you to write the book? And we'll talk about a couple other things
Was,
as the time winds down
yeah.
here.
Well, it was partly the statute because I was around writing opinion pieces when the statute went up in 2013 and also when it came down about 10 years later. Um, I was really intrigued by how little I knew about this very prominent Mainer. My other books are largely about Maine figures, other Maine figures, George Mitchell, the Democratic Party's wonderful figures from the Ed Muskie era on forward, and Albert Beliveau, who was a state judge and the first Franco-American to serve on any court in Maine. So here's Fuller, and he was U.S. Chief Justice for 22 years, the third longest tenure after Marshall and Taney of any Chief Justice up to this time. And I knew practically nothing about him. So as a journalist, when I don't know something about something that I find very interesting, I really want to go to work on it. But one trail leads to another. I figured I'd spend a year on this book. I ended up spending 2 years on the book, and I could have spent more. So it's that idea that you're unraveling the thread and it leads you somewhere else and then somewhere else beyond that. I'd say curiosity is a very strong trait with myself and how I go about my business.
Well, we're curious. What's next?
Well, I am working on a book about a guy who is a whole lot more popular in Maine than Melville Fuller. was anyway. We don't know how much his stock has improved since I wrote the book, but no, the next book is about a wonderful reform governor named Ken Curtis, who grew up by chance in another figure you'll meet in the book is Oliver Howard, who is the namesake of Howard University, the first and only head of the Freedmen's Bureau, who was known as the Christian general in the Civil War. He's not quite as famous today as Joshua Chamberlain, but he was an important figure, and the Freedmen Bureau established what we now know as the historically Black colleges and universities, a good example of something that was separate, but perhaps not entirely undesirable. So I cite that in the book here. But Ken Curtis was born in the same town, Leeds, Maine, that Oliver Howard was. And he was from a farming family, and he decided that farms were done. So his father literally working himself to death. He went to Coney High School in Augusta, graduated essentially at the top of his class, went to Maine Maritime Academy, and then decided to enter politics. And he became a Democratic governor at the perfect time. It was the middle of the Great Society period. And he carried on many Great Society-like programs throughout his entire tenure as governor, which ended in 1974. As I like to say, if there's something you like about Maine state government, it probably started with Ken Curtis. So he had a huge effect on this state, and it's nice to be back on home ground. You know, everybody I need to talk to is in Maine or maybe Vermont in a couple cases. So I don't have to go to Washington and Chicago to do my research, which was arduous, and some of it was during the pandemic. And I have to say that was hard work. This is a little easier and more fun.
Well, we're so glad you put in the hard work, Doug. It's a major contribution to Supreme Court history. We're grateful for it, and we were delighted to get to share time with you today about the book. I'm going to hold it up and advertise it for you. Calm Command. It is available in our gift shop at www.supremecourtgifts.org. The holiday season is approaching. We recommend it, and we are, as I say, very grateful that you made all the effort and put in all the hard work to write an important book about Chief Justice Fuller. Thank you so much for being with us today, Doug. And if you have any other comments you'd like to make, please do.
Just to say, this is a wonderful opportunity. I don't often get on a kind of a national stage, so that's my reward for having ventured into a field that I was pretty ignorant about at the beginning, and I hope I've made up for that. But it's always great to have an audience, and particularly ones that's tuned in on this book. So
Well,
thank you.
We're grateful for your work. Our next virtual lecture will take place on December 16th at noon. Robert Post will be joined by Robert Gordon to discuss Robert Post's groundbreaking Oliver Wendell Holmes devised volume on another of our Chief Justices, William Howard Taft, and the Taft Court. Registration will open on the Society's website at www.supremecourthistory.org next week. And finally today, a survey will go out later this afternoon to everyone who registered in advance. Please do respond to the survey. We added these virtual programs during the pandemic, and we do plan to continue them. They've proved to be very popular and informative, as today's was. Your feedback on these programs is critical to us to make them as engaging and interesting as possible. So thank you all for your participation today, and we look forward to you joining us again on December 16th. Thank you, Doug. It's good to be with you today.
Thank you.